Ever signed a fixed-term contract and then maybe wondered, what actually happens if this thing ends early? Before the date written down. Or more to the point, what are your rights if it's cut short and there wasn't really a good reason for it?
Yeah, that's a crucial question for a lot of people.
Well, today we're doing a deep dive into exactly that. It's a really significant bit of employment law here in Kuwait. We're looking at what happens when a fixed-term contract gets terminated prematurely without a proper legal basis.
Exactly. We're really zeroing in on Article 49 of the Kuwait Labor Law. You can think of it as like the main reference point for what happens when one of these fixed agreements, with a set end date, is broken off early.
Right. It sets out the basic rule for compensation.
The fundamental principle, yeah.
So our mission today isn't just to walk through the standard calculation for that compensation, though we'll definitely cover that.
We will.
What we really want to do is unpack the exceptions, the finer points, the nuances that can actually change the outcome quite a bit.
That's where the real detail lies.
Yeah. This is all about giving you practical knowledge, whether you're the employee in this situation or maybe you're an employer managing these kinds of contracts. Okay, let's unpack it. Article 49. It lays a foundation, right?
It absolutely does. The core idea, the starting point in Article 49 is this. If a fixed-term contract is ended by one side before its agreed finish date, and importantly, without a valid legal reason,
okay,
then the party who ended it has to compensate the other party, compensate them for the damages they suffered because of that early termination.
So it's about making the other party whole, in a sense.
That's the principle. It's a protection mechanism, really, for both sides against arbitrary endings.
Yeah.
And this default calculation we'll talk about, it serves as a pretty strong baseline. It particularly protects employees who, could face real financial hardship if their job suddenly disappears.
Okay. And when we talk damages, the law actually gives a clear starting point for calculating compensation, doesn't it? It mentions the salary for the rest of the contract.
Precisely. That's the default method. You start by looking at the wages the person would have earned for the time that was left on the contract.
Right.
So let's take an example. Say someone's on a 2-year contract. They've worked for 6 months.
Okay.
And their monthly salary is, let's say, 600 Kuwaiti dinars. If the employer terminates the contract right then, without a valid legal reason, the initial calculation would be for the remaining 18 months.
So 18 months times 600 dinars.
Exactly, which comes out to 10,800 dinars. That's the potential starting figure for compensation.
Wow. Okay, that's a substantial number. That really gives you a concrete starting point. But as you hinted, that's not always the final amount, is it? What are these exceptions we need to know about?
Right. So Article 49 itself actually builds in 2 main exceptions that can change that initial figure.
Okay, what's the first one?
The first one is if the employer and the employee actually agreed on something different in the contract itself.
Ah, so they can basically write their own rule for this situation.
They can. Within limits, yes. They can mutually agree on a different way to calculate the compensation if the contract ends early.
Like a specific formula or a fixed amount.
Exactly. A common example you might see is a clause saying, look, if this contract is terminated early by the employer without cause, the compensation will be limited to, say, 3 months' salary.
Regardless of whether there were, 18 months left?
Correct. Regardless of the remaining duration. If both parties knowingly and willingly signed up to that specific term in the contract, a court is very likely to respect that agreement and use the 3-month figure instead of the full remaining salary calculation.
Interesting. So that initial contract negotiation is really key.
It is. For employers, having such clauses, if drafted properly, can offer some predictability, but they have to be fair and, legally sound.
Okay, that makes sense. It hinges on what was agreed up front. What's the second exception that could alter the compensation?
The second major exception involves the court's discretion. The law actually allows the court to potentially reduce the compensation amount.
Reduce it from that default calculation.
Yes, or even from a contractually agreed amount in some cases.
Right.
Though usually it's about reducing the default. The court can do this based on the specific circumstances of the case.
Circumstances like what?
Like looking at the actual harm, the real financial damage suffered by the person whose contract was terminated. It recognizes that just calculating the remaining salary might not always reflect the true loss.
Can you give us a scenario where that might happen, where a court might say, okay, the default is X, but we're awarding less?
Sure, let's go back to our employee. 2-year contract, terminated after 6 months, 18 months left. Default calculation is 10,800 dinars.
Right.
Now, imagine that employee is quite proactive or lucky, and they find a new job just, say, 3 weeks after being terminated.
Okay.
And let's say the new job pays a similar salary, maybe even a bit more.
I see where this is going.
Exactly. In that situation, the employer might argue, and the court might agree, that the employee's actual financial loss wasn't 18 months of salary. It was maybe just those few weeks they were unemployed.
So the damage was mitigated.
Precisely. The actual damage was significantly less than the full 10,800 dinars. So the court has the power, to discretion, to reduce the compensation awarded to reflect that reality.
That's fascinating. It tries to balance the protection against unfair dismissal with ensuring the payout relates to the actual financial hit someone took.
That's exactly that balancing act.
Yeah.
Protecting the employee, but also ensuring compensation is grounded in the real impact.
So it's clearly not just about the strict letter of the contract duration. The real-world outcome matters significantly. Okay, this obviously has big implications.
Yep.
Let's pivot to some practical advice, maybe starting with employees. What should they take away from this?
Okay, for employees signing a fixed-term contract in Kuwait, the absolute #1 piece of advice is read your contract carefully, thoroughly, before you sign it.
Don't just skim it.
Don't just skim it. Pay really close attention to any clauses about termination. How is it handled? And specifically, look for anything mentioning compensation if it ends early. Understand what you're agreeing to.
Solid advice. And once they've signed and are working, what then?
Keep copies. Keep a safe copy of your signed contract. And also keep records of important communication with your employer emails, formal letters, anything relevant.
Okay.
Because if your contract is terminated early and you believe it wasn't for a valid legal reason, you'll need evidence. Any proof you have showing that termination lacked justification could be absolutely crucial if you decide to make a claim for compensation.
Right. Documentation is key. That's really practical stuff. Now let's flip it. What about employers? What are the key considerations for them from Article 49?
For employers, the main takeaway is, honestly, try to avoid terminating fixed-term contracts early unless you have very clear, legally justifiable reasons.
Because the default compensation can be quite high.
Exactly. Terminating arbitrarily or without solid grounds recognized by the law can lead straight to that significant financial liability, paying out the salary for the rest of the contract term.
Are there proactive steps employers can take, maybe contractually?
Yes. Going back to that first exception, employers can consider including a clause in the contract that clearly specifies an agreed-upon method for calculating compensation for early termination.
The 3-month salary example we discussed.
Precisely. If carefully drafted, clear, and genuinely agreed to by the employee when signing, such a clause can offer more predictability and potentially limit exposure compared to the default rule.
But it has to be done properly.
Absolutely. It needs to be fair, transparent, and compliant with the overall Kuwait labor law. You can't just put anything in there. It has to be reasonable.
So for employers, have strong justifications if you terminate, and perhaps consider carefully worded, agreed-upon compensation clauses.
Got it.
Okay, let's try and quickly summarize then. What are the absolute core takeaways from our deep dive today on this compensation issue?
Okay, I'd say 3 main points. 1, the basic rule terminating a fixed-term contract early without a valid legal reason means the terminator owes compensation.
Sure.
2, the default calculation for that compensation is usually the salary for the entire remaining period of the contract.
Starting point, yeah.
The starting point. And 3, this default amount isn't set in stone. It can be changed mainly in 2 ways, either by a different calculation method already agreed upon in the contract itself, or by a court deciding, based on the actual situation, particularly if the terminated person found other work quickly, that the real financial damage was less than the full remaining salary.
Perfect. So a clear default, but with flexibility based on agreement and actual harm. That really clarifies things.
It does. And understanding this for both sides can hopefully head off misunderstandings or, expensive legal battles down the line.
Well, that was certainly a thorough look at Article 49. It's clear that while the law sets a strong baseline for compensation, these potential adjustments, the pre-agreed terms and the court's view on actual damages, add really critical layers.
They do. It highlights how vital it is to understand your specific contract and the legal framework around it.
Absolutely. It really underscores the importance of knowing your rights, knowing your obligations, and reading that contract.
Couldn't agree more. Essential knowledge for navigating employment here.
Okay, so on that note, here's a final thought for you, our listener, to mull over. When you think about this balance the freedom for parties to agree on terms in a contract versus the legal safety net provided by Article 49. How do you think these rules might influence longer-term things? Like how individuals plan their careers in Kuwait, or how companies develop their overall staffing strategies?
Interesting question.
And thinking beyond just the money we focused on today, what other factors, maybe non-financial ones, could be significant when a work contract ends unexpectedly? Definitely something to consider.